This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we are going to speak about the law of unintended consequences and how it applies to the tort of bad faith. The law of unintended consequences is not statutory. No state or federal government has enacted it into law. No executive has signed the law. It is rather a law of the nature of people. It is an adage or idiomatic warning that an intervention in a complex system always creates unanticipated and often undesirable outcomes. General observation requires the hypothesis that actions of people, especially of governments, will always have effects that are unanticipated or unintended. It has been proved. Economists and other social scientists have heeded its power for centuries. Regardless, for just as long, politicians, insurers, and popular opinion have largely ignored the law of unintended consequences to their detriment. There is no common law duty for a court, especially in a heavily regulated sector of the economy like insurance, to create new rules. Every court should be loath to invent duties unmoored to any existing precedent. The law of unintended consequences counsels against it. To find a good illustration of the law of unintended consequences, one need only look no further than the Supreme Court's decision in Williamson County Regional Planning Commission versus Hamilton Bank of Johnson City, a 1985 decision. The Supreme Court's actual holding was pedestrian. The Hamilton Bank's takings claim was unripe because the bank had not exhausted its administrative remedies, specifically its right to ask the county for a variance to develop the property in a manner proposed. In dictum, however, dictum in the sense that the court's pronouncement was at that point unnecessary to its decision, the court went on to say that the bank's claim was not yet ripe for a second reason. That reason, too, was couched in terms of exhaustion, that under state law a property owner may bring an inverse condemnation action to obtain just compensation for an alleged taking of property, and that until the bank utilized that procedure, its taking claim was premature. The court's implicit assurance, of course, was that once a plaintiff checks these boxes, it can bring its takings claim back to federal court. That assurance proved illusory. State court judgments are things to which the federal courts owe full faith and credit. That obligation means that takings claims litigated in state court cannot be relitigated in federal court. Thus, by all appearances, inadvertently, Williamson County all but guarantees that claimants will be unable to utilize the federal courts to enforce the Fifth Amendment's just compensation guarantee against state and local governments. The law of unintended consequences applies as much in jurisprudence as anywhere else. Bending a rule to accommodate one litigant doesn't always achieve better justice. Sometimes it just sows confusion in anyone trying to figure out what a court might do in other cases in the future. A prudent court will take the lesson to leave rulemaking to the legislators and administrators even when the outcome appears unjust. The orderly development of the law is not without rough patches, but it is better than living under the law of unintended consequences. In addition, as one dissenter said, that the majority's desire to cure all wrongs by eviscerating the doctrine of governmental immunity, while well-intentioned, was fraught with the law of unintended consequences. Depriving governmental officials of governmental immunity when making policy decisions when making sentencing decisions and when running the government would certainly cause most of us to rethink the traditional notion of public service. Courts will often work strenuously to avoid making decisions that will result in difficulties in the future by application of the law of unintended consequences, which causes more problems than the decision may cure. In my opinion, it is the well-intentioned creation of the tort of bad faith helped one insured only to cost hundreds of millions of dollars, if not a few billion, to those unaware purchasers of insurance who may pay more in premiums than they would have had if the tort had not been created by the California Supreme Court. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available as a Kindle book and a paperback from Amazon.com. This video is part of my blog, Zelma on Insurance, which is available to anyone free by clicking on the URL zelma.com/blog. And you can subscribe to the blog and will receive a new blog post, usually 5, sometimes 6 a week, and access to the more than 4,500 blog posts already in service. You can also subscribe to my videos on rumble.com and youtube.com. And if you found this blog and or video to be of use to you or your business, please tell your friends and colleagues so that they can also subscribe to the blog and the videos. And you might, if you want to see further information, subscribe to my Substack publications or my locals community, where for a small fee you can get much more detailed information on insurance law and insurance claims. Thank you for your attention.